PA. She then scaled higher with a Master in Business Administration Finance from the University of Malaya, in 2007. Jasmine has more than 20 years of corporate experience, and she is also well-versed in wealth management. She sees personal wealth management, retirement, and estate planning as an indispensable part of financial planning, be it for families or businesses. Her knowledge in this area has allowed her to retire early from corporate work. Currently, she is pursuing her passion in wealth management and estate planning for families and businesses. The second speaker for today is Ms. Nurbaizura binti Muhammad Naim. Ms. Nurbaizura is a lecturer from Taylor's University with more than 20 years of teaching experience. She is from the School of Management and Marketing, and her areas of expertise are in the study of consumer behavior, brand, and marketing. Without further ado, I will pass the floor to Ms. Jasmine.
Good morning, ladies and gentlemen. Thank you for joining us this morning. I must also thank Taylor's Business School for inviting me to share with you on today's topic of estate planning. Is this effort worthwhile? So as Cheryl has mentioned, many know it's important to write a will, but not many have actually taken the action. So ladies and gentlemen, we are already into the 11th month under the threat of COVID-19 pandemic. Nobody expected this to happen, but it happened. So from now onwards, we better prepare ourselves for the new norm, yeah? And it is also true for our wealth and estate planning. Well, why not we just do a quick survey among ourselves and see how many of us have done our will. I will share a Slido screen. What you need to do is either you go to Google, go to slido.com and key in the code 22592, or you can just scan this QR code and you will come to this question. You come into the Slido, you'll see two tabs. One is the Q&A, and the next one is the poll tab. The Q&A is where you can actually type in your questions. Then the next one to it is the poll tab. You click on that, you'll see the survey questions. But kindly do this quickly because we only allocate about 3 minutes for this part. Can you see the questions? Oh, sorry. Okay. All right. Can you see the screen, the Slido screen? You can either log into slido.com and key in the code 22592 or just scan the QR code and then tap on the poll tab. Okay, first question. Have you written your will or wasiat? Just click either yes or no. Okay. Are you done with the first question? Okay, can we move to the next question? If you have written a will, do you inform your beneficiaries where your will is kept? Yes or no? Oh, that's good. Out of 13, actually majority of you have actually written a will and informed your beneficiaries where you keep your will. Next question. If you have not written a will, what is your reason for not doing so? This you may take more than one reason. Let's take more participants. Okay. 8, 10, 11. Okay, out of 15 participants here, I can see that the main reason for not writing a will is actually don't know where to get the service, and then followed by I can't afford the fee, and then I don't think it's necessary, and the last one is I don't have the time. Okay, all right. So now let's go back to our slides here. Now we will see my slide. Wait a minute. Okay, from this result from the survey, actually majority of people who haven't written a will, the reason is they don't know where to get the service. And I'm actually glad to see that from the people who actually participate in the survey, majority have done a will. Okay, so the purpose of okay, let's see this one. Okay, ladies and gentlemen, you see this news. Sunday Times, 40 billion unclaimed cash and asset left by the dead, and the Star estate worth 60 billion left unclaimed. And you can see, ladies and gentlemen, the figures actually increase over the time from 40 billion in 2009 all the way up to last year. The figure actually stood at 70 billion. So what happened? There is money, but nobody is claiming. Hence, today, the objective of our webinar is to provide you with some basic but fundamental knowledge about estate planning, and stay on for a kisah benar. And then at the end of the webinar, you decide for yourself whether it's worth your effort to execute your estate planning. Now, what is estate then? This estate is not referring to the plantation or oil palm estate, yeah? It actually means asset owned by a person at his or her death. And what is estate planning? It's actually a process of making arrangement for, number one, the protection and preservation of asset, for the provision of the asset to the beneficiaries that you intend. Okay. When a person die, leaving a valid will, is he said to die testate, whereas if a person die without leaving a valid will, then he is said to die intestate. And next, where does this estate planning come into the context of personal financial planning? Well, personal financial planning actually encompasses three parts: wealth accumulation, wealth protection, and wealth distribution. We all work hard, yeah, for a living, and of course, if possible, we want to accumulate some wealth for our future or for our loved one when we live. So along the way, we need to protect our wealth. Ladies and gentlemen, medical cost is very expensive nowadays. Have you heard of any incidents whereby critical illness suffered by a family member can actually wipe out the whole family's lifetime saving? That's why if you want to protect your wealth and make sure it's available for distribution, insurance and trust play an important role. And at the end of the day, how you want your estate to be distributed, this is where estate planning will come in. Having said this, the whole estate planning process actually should start from here. How to accumulate our wealth, how to protect it so that it's available to be distributed smoothly to the intended beneficiaries. Now we come to this. Find out why is estate planning so important. Yeah. Okay. Firstly, a will is a declaration of wishes, how a person wants his estate to be handled and distributed upon his demise. So if you have written a will, you can actually appoint someone who you trust, who can handle your estate when you pass away. So this person here can be an ordinary person or it can be a corporate trustee. So in your will, you can spell out who is to inherit what from you and in what proportion. If you don't do this, then you are leaving it to the law to decide for you. I give you an example. Let's say Mr. A. Mr. A is very busy. He never had the time to do his will, and suddenly he passed away and survived by his father, 80 over years old, and then his spouse and his children. Okay, well, since Mr. A didn't write a will, then his estate will be distributed under the Distribution Act. And his father is actually eligible for 1/4 of his estate. And if so unlucky, the father soon also passed away, also without a will. That means his estate, including this 25% inherited from Mr. A, is going to be distributed also under the Distribution Act, meaning his children or Mr. A's sibling are going to have a share in this 25%. So can you imagine that Mr. A's sibling are also having a share in the house that the wife and the children are living? I believe, ladies and gentlemen, you don't want this to happen, right? Okay, and then okay, when you write a will, you spell out who is to inherit who and you appointed an executor. Definitely is going to minimize the time spent on the estate administration, because upon your demise, the executor will just need to apply to the court for a grant of probate, compile your estate, and then clear all your debts, and he can distribute according to your wishes. Ladies and gentlemen, if you have planned your estate properly, you can actually minimize cost of asset distribution. I give you an example. Let's say you have some private company shares, let's say worth 100 million. So if you were to transfer this during your lifetime, it is subject to stamp duty at 0.3% of the market value. Whereas if you plan it properly and will these private company shares or your business under your estate distribution, then the stamp duty is 10 ringgit per transfer document. So ladies and gentlemen, you can work out how much stamp duty you can save. Next, estate planning is important for the provision for the maintenance of dependents. Dependents here normally are our family members who depend on us financially. Upon a demise of a person, his estate will be freezed until a letter of administration or a grant of probate is obtained. So during this time of months, sometimes the process can actually drag into years. Who is going to pay for the cost of living and the children education of the family, right? And the situation can actually be more serious if the person has growing up young children who are minor between 18 years old. Being minors, they are not legally capable to inherit estate. And okay, under the law, if one of the parents pass away, the other parents will become the legal guardian automatically. But what happened is so unlucky, touch wood, both of them passed away together and they didn't write a will. They have never appointed a guardian for their children when they are not there for them anymore. So very pitiful, you don't know where and who the children will end up with. So if you want to appoint a guardian, right, who you believe is is you can trust and someone who can really love your children, you can appoint it, you can appoint her or him in your will. But of course, you must also inform the person so that you don't caught the person by surprise. How come suddenly he or she is the guardian for your children without his or her consent? Okay. And lastly, this goes without saying, if you have written everything clearly in your will, you can avoid dispute among your beneficiaries. Okay, so far so good. I proceed from here. Okay, now we look at the stages of estate administration and distribution. Basically, the whole process divided into 2 stages, and the process will actually very much depend on whether it's a testate or intestate. Okay, if a person die testate, then the appointed executor, what he need to do is to go and apply for a grant of probate from the High Court. So once he get the grant of probate, he can start to compile what you have, your estate, okay, and then pay off your liability and then start distribution. Whereas if a person die intestate, among the beneficiaries, they have to appoint, they will decide who is going to apply to be the administrator, and this person will have to go and apply for the letter of administration. Once he get the letter of administration, then only he can compile and figure out what you have, what are your liabilities. Okay, after paying all your liabilities, then come into the second stage to distribute your estate. And under the relevant law, if a person pass away with a will, that means he passed away testate, then very simple, the executor will just distribute his estate according to his wishes under his will or whatsoever. But in the case of intestate, the administrator have to distribute according to, for non-Muslim, for people from West Malaysia and Sarawak, according to the Distribution Act, whereas for Sabahan, go according to Intestate Succession Ordinance. As for Muslims, yeah, if they die intestate, their estate will be distributed according to the Faraid law. And there is another additional requirement before they get the letter of administration, they need to go to the Sharia court to get the Faraid cert. Okay, then ladies and gentlemen, kindly see this general asset. Why I say general asset? Yeah, because they are basically 3 types of asset. Wait, sorry. 3 types of asset. First type, specific asset. They are assets which are regulated by specific legislation. Like for example, your EPF, your insurance, your takaful, SOCSO, and government pension. So this asset, if you have done your nomination, they won't fall under your estate to be distributed under your will. Okay. And second category is assets under contractual arrangement. For example, your asset that you have already parked under your trust, or you have assigned your insurance, or a joint account in the bank with joint holder survivorship clause, or joint account of unit trust. Here I have to highlight one point here, because many people thought that, oh, once I open a joint account with my spouse, then if I pass away already, my spouse will automatically become this sole account holder, and he can operate the account, take out the money. So, but unfortunately, this is not 100% true. You have to see whether the accounts has provided for joint holder survivorship. If not, upon demise of a person, the joint account will also be freezed until the bank is presented with a letter of administration or a grant of probate before they can release the money to the surviving joint account holder. So That's why it's very important when you open a joint account in the bank, please check properly under the term and condition whether there is a provision for joint holder survivorship clause. Okay. Okay. By the way, for unit trust, is always on this joint account survivorship clause provision. And general asset are assets. Okay, before that, sorry, for asset under contractual agreement, there's one more thing for your properties under loan financing. Okay, many people like to invest in properties with the bank financing, but please remember, so long as the property is not the loan is not fully settled, it won't fall under your assets to be distributed. Yeah. So if you feel so good about having a lot of properties, please make sure that you have other assets or you have covered the property with the insurance. In case of your demise, the insurance compensation can be used to pay off your loan, or you have other assets to be used to pay off the loan or to continue to service the loan. So ladies and gentlemen, when we leave one day, we want to make sure what we leave behind are assets, not liability, not burdens. So in case you don't plan properly and you leave behind a lot of property still under loan financing, your loved one may have to be burdened with this loan servicing. Yeah, and if your family member cannot continue to service, they may have to put the property for sales. All right. Now we look at general asset. These are assets which are other than this specific asset and the asset under contractual arrangements. Okay, and under this part, it is not only covering the physical asset, but under today's digital era, please also remember to account for your digital asset. Like for example, you have a lot of important documents that you save in the cloud. You have your social media password. You have your password to your e-wallet. Yeah. So these are also important assets that you should actually plan out properly. Who should inherit this asset and how they can get access to it. Okay, remember just now we talked about the letter of administration, right? So where to get the letter of administration actually depends on whether the assets are movable or combination of movable and immovable, and whether it's below 2 million or above 2 million. Okay, ladies and gentlemen, please remember that whatever asset that you leave behind, right, before the executor or the administrator can distribute, all your liabilities and creditors must be paid. It means estate under a will, or in case of no will, as long as it falls under your estate, it is number one, subject to creditors' claim. Number two, it has to go through the process of getting the grant of probate or letter of distribution, letter of administration. Now we see this legal requirement of a valid will. Okay. In order to write a will for a Sabahan, he needs to attain the age of 21 years old, whereas for people from West Malaysia and Sarawak, 18 years is the minimum age to write a will. Okay. And at the moment of writing a will, the person who write a will called a testator must be of sound of mind, and the will must be in writing except for privileged will. The will can be written in any language, and very important, the testator must sign in the presence of at least 2 witnesses, and vice versa, meaning after the testator sign, the witness him signing, and then witness will sign. And please remember, your witness cannot be the beneficiary nor the spouse of your beneficiaries. If not, the will become void. Okay, next we see when can a will be void. Okay. If you write a will previously and then now you change your mind, you want to write a new one, the latest will override your previous will. Or if you don't want the old will already, you can physically destroy the will. And if you write a will before you get married, please remember to write a new one, because any will written before a marriage will automatically be void, unless at the moment you are writing there is a provision for this contemplation in a marriage. Okay, and you can also write in writing to declare that whatever will you write before is revoked. And lastly, a will become void when a person convert to Islam. So remember, a marriage will void a will, but not a divorce. So if you, in a divorce case, please always remember that the old will is still valid. So if you don't want to allocate or inherit anything to your former spouse, please remember you must write a new will. Okay, ladies and gentlemen, now how should we plan for our estate then? Up to now, you should know that estate planning is more than just writing a will. Yeah. Then you must consider whether you want all this estate to fall under estate or not, because estate is subject to creditors' claim. Estate is subject to distribution. The grant of probate and this letter of administration, which is will take you a lengthy process. Okay, so if you want to do a proper estate planning, make sure that you have done your nomination for your EPF, your insurance, your SOCSO money, your PRS, and so on, whereby this part of the money can be released very fast, much faster than the money, your asset under your estate. So this is very important, because this money normally will be used to pay for the cost of living, while the beneficiaries are waiting for the letter of administration or the grant of probate. Yeah. Okay, you might also consider to save aside some money in unit trust account with joint holder, or a bank account with joint holder survivorship provision, so that upon our demise, our loved one, whoever you can trust, can actually go and withdraw the money from this account for their day-to-day expenses. And for people who maybe people in the business, they may want to protect their asset from creditors' claim, they can actually create a trust. Because asset under a trust will be creditor proof. Okay, and also please ensure you have proper filing of your legal documents, your statements, so that your executor or this administrator don't have to look up and down, don't know where you file your title, don't know where you file your registration card, and so on. Okay, and it's advisable for you to have your own personal asset inventory booklet and update it from time to time, so that upon our demise, the executor, once open this book, he will have a list of what asset you have, what bank account you have, what are the bank account numbers, where you keep, what property you have, which land office that they need to go to do the transfer, and so on. Okay, ladies and gentlemen, this is the last slide for me. Now, I would like to pass the floor to Noor for her kisah benar.
Thank you, Jasmine, for the interesting presentation. So now I will take over from where Jasmine has left off with my session. So let me share first my slides, yeah. Okay. So as what Jasmine has mentioned just now, and I'll be covering a little bit of what I went through. It's this case Habana, it happened in 2019. Okay, so what happens is my husband passed away, and so there was no will. Okay, so at that time there was a lot of challenges, like what do I need to do? Where do I claim his estate? Okay, there was no one to advise me, so it was a lot of online searching and getting information, and there were others that were actually telling me, oh, you need to go to the court to do this, the Sharia court. And I was thinking like, okay, Sharia court, that means lawyer, that means fees. And then somebody suggested, Amanah Raya. So, okay, fine. So I was searching information for that. Then I look at Amanah Raya, the fees can be a bit pricey. Then I went on searching for information, and I discovered there was another option, of which I'll show you in a while. Okay. So first thing I did was, I'm going to share with you what are the documents needed in order to ensure that, yes, the process still can go on even if you don't have a will. And the second part is the process that I went through to claim the inheritance. Yeah. So I'll start first with nominating the beneficiaries. Now, why I chose these two is because these are the two items, EPF, and if you have Lembaga Tabung Haji or Pilgrimage Fund, it can be done very quickly. Okay, so what I did was I actually presented the documents to EPF, and they told me that they could process it within a month. Actually, they did it much faster. Okay, it was, I think, less than a month, about 3 weeks. And at the time that I did the presentation, I presented the documents, I also did the nomination for myself. That means I did it for my children. And that's where I discovered that I had a child, okay, below 18. And that's where EPF mentioned that you can't nominate anyone below 18. This was in 2019 because of the age issue. So I had to park her portion of the EPF nominee under one of my child. Yeah. So that was one. Then later this year, I actually spoke to one person in EPF. She mentioned that yes, you can do it. Okay, so I put the notation here that you can still park your nomination under a child that is 18, but in the case of a Muslim, in the event of a death, the portion of the child that is under 18 goes under Fara'id, the Muslim law. But for non-Muslim, it stays the nominees, whoever you nominate. That's what I discovered when I was talking to EPF this year. Tabung Haji also did the same thing. They don't allow anybody with the age under 18. So again, the same thing, because I had a child below 18, I had to park her portion under one of the other child who's above 18. And Tabung Haji also did a good job. They actually cleared, they will tell you that it's 1 month, exactly close to 1 month, the whole process is done. That means if you have nominees, if you nominate names in this, the clearance is very fast. But if there are no nominees, all of this, I'm talking about the Muslim aspect of it, all of this goes to the estate, harta pesaka. The other one that you can do is going to Perkeso or Sokso. And what it does is you submit your claims. Again, Sokso was quite efficient. They actually process the whole claim within a month, and you get like a monthly, I would call it a pension, okay, for yourself, and then for any of your children below 18. Once the child hits 18, and if he or she gets into a university, you can go back to Sokso to claim, I would call it, the monthly installment or monthly payment until the child graduates degree. All right, so this is some of the things that you can do in the event of a death of your loved one. Now, the next one I suggest is, and also what I've done, and also what my late husband had, okay, so the documents to be compiled, or you should filed, okay, is first and foremost, the most important one will be your SNP, that will be your sales and purchase agreement of your house or any property that you have. If you are still paying for it, you will need the SNP. But if you've already finished payment, you will need the deed, the title of the house or land. Yeah. Second one is you also need your house and land assessment bills. This is what we call cukai pintu and cukai tanah, whatever, here. So you need to keep copies of it, because when you're submitting the documents, this is one of the requirements. So they're very, very particular. I had to go 3 rounds of submission, physical submission. I mean, I actually went to submit the documents, the hard copy. They checked it and they said, nope, we're not happy with this. You don't have this. So go back and get back the documents needed. So it was very, very challenging at that point of time. Then, as Jasmine mentioned just now, if you have a house that is not, fully paid, car not fully paid, what happens is, again, I discovered JPJ allows you to renew the road tax up to a maximum of 3 years. Okay, and the road tax can only be renewed on a 6 months basis. So every 6 months, I have to go to either the post office or JPJ to renew the road tax. This is with cars that have not been fully paid. Up until 3 years, you can go to the JPJ and appeal in case you still have a lot of payment for the car. You can appeal to them, but this was the process I went through to renew the road tax for every 6 months. Okay, if you have insurance, you can do that. So keep a file of it, and then bank documents, okay, bank account and so on. Because the minute there is death, you need to go to the bank and inform them. All right, inform them. And you need to get the outstanding loan, that outstanding loan is in car loan and house loan and so on, because these are the documents that you need to submit later, right? We're going to come to that. And then ASB and unit trust, okay, again, it requires an LA. So it's not something that you can present at, the death certificate and, get the money. It's not that easy. SSPN, this is Scheme Simpanan Pelajaran Negara. After I've gotten the LA, and this is also one of the, I would call very challenging. It took more than 4 months for them to actually, get back the money, which my late husband actually did it for our children. And one of the requirements of SSPN is when you submit the documents, you need somebody in the government to certify it. If you don't have that, you need the Ketua Kampung to do it. So that was also another challenge. I had to go around looking for somebody in the government with certain grades. They're very specific about that, to certify the documents before submitting to them. One good thing about SSPN is the fact that they will match dollar for dollar with insurance. And so, for example, if you have a saving, you save for your children, let's say 5,000. So the insurance will cover another 5,000 to that. Okay, coming to joint account, it is true. What happens again, at the minute the bank knew that there's death, they froze my account since the account was a joint account. And the worst challenging part here, it was my salary account. So there's no such thing as, yeah, you can operate, or I'm the only one who's signing it. To the bank, they recognize it as, hey, this is a legal aspect of it. We're not going to allow it, so it's frozen. Okay, then during my, I put it in red, you can see that, during my discussion with some of my colleagues, she mentioned that, does your husband have digital assets? So I'm looking like, okay, I'm not very sure about that. So digital assets include like, social media accounts, Instagram, Facebook, or if you have Bitcoin, okay, and PayPal, or if you store, your creative ideas in cloud. For example, you're a famous photographer and you have pictures, or you store your music online, so on. So does it fall under this? So I said I have no idea about that, but that's a very interesting aspects of it to look at. Okay, so I'll go to the next slide here. While I was searching online in terms of how to claim the assets, I discovered that there's one law for Muslim and there's another law for the non-Muslim, and the process can be done for Muslims and non-Muslims. And also at the same time, when I went to this is the document that I got from the land office. I think you can barely see it. I also cannot see the document that was given to me. One of the other, I think worst experience I had with this is the fact that when I did, online application, as you can see here, I did the online application. They did not inform me that you're not supposed to use Google Chrome. You're supposed to use Internet Explorer. So I think after the third time I submitted my application, I discovered that the information was missing. It was not saved. So I went back, did it again. This time I was quite smart. I did only like 2 claims and I closed and went back, it disappeared. I thought there was something wrong with my laptop. So I told one of my other children, why don't you do it in your laptop and see whether it works or not? And I discovered that, yeah, same problem. So I think the 4th or 5th time, I finally called the office and said, what's going on? how come, you know, the information that I saved online disappeared? And I said, oh, you should be using Internet Explorer. So when I look at this form that they gave me, there was no mention of, you know, Internet Explorer. It's just that you go to this website and you do what's necessary. The other aspect that I also discovered that when I was doing this online claim that, you know, assets are divided into movable assets and immovable assets. And the application was basically in Bahasa. So it's harta mudah alih and harta tak alih. So that's what happened. I mean, some of the challenges that I went through. And I also, if you notice, okay, let me share with you this one. Another document. Are you able to see this one? Yep. Okay. So this is, I'll cut short very quickly with what I went through. This is the process of claiming the estate in the event there is no will. So I divided into two, the no will or the wasiat, no wasiat, and the will and wasiat. And I'm not going to cover this part here because that's not what I did. I'm just going to cover one aspect of it, which is the one in pink here. Okay. And as I mentioned, when I was going through the process, I discovered that there's 3 ways for you to claim it. Okay. First is if you go to Amanah Raya, if you have only cash, or they call it movable assets, up to 600,000.
Sorry, we can't see.
Okay, sorry. Let me try again. Hang on. See, think. Oh, yeah. Okay, let me share again. Sorry about that. Are you able to see this? Yep. Okay.
Yes, we're able to see.
Okay, very good. All right, thank you. So when I started off, I discovered that this is the 3 ways that I could actually claim the estate. First one is going to Amanah Raya for assets. This is just for cash. They call it movable assets up to 600,000. The second one is the local land office, JKPTG, they call it. It's called movable assets and immovable assets, up from 600,000 cash, plus other assets, 2 million. And then of course, if you have assets more than 2 million, you need to go to the court. All right, so we're going to go through the process of claiming from the land office. So this is the process that you can see. First thing you need to do is assess your assets. When I say assets, I mean this includes your debt. So my late husband had debts. We're talking about house and car. So when you're filling this information online, there is a section where you fill in terms of hutang, okay, and you fill in that part of it. Yeah? So asset evaluation, you roughly, it doesn't have to be exactly accurate. You know, your assets have to be like, you know, 2 million and so on. It's between that range. So do assets evaluation, and that's what I did. You know, after reading online, these are the information required. And then you have to determine which jurisdiction. For example, because I'm in Shah Alam and I bought you know, a house in Shah Alam, so the place that or the land office, the local land office that I can claim, let me submit my documentation, is the Shah Alam one. If you don't have in, you know, Klang Valley and so on, but you did buy an asset somewhere else, let's say in Johor or Kedah, then that's where you need to submit the documentation. And here I put there more than 5 months of submission. That means from the time of submission of the documents until the time that they give you a court date. When I did that was 4 months. Now the time frame has gone up to more than 5 months. Okay, so this is what I mentioned just now. Amanah Raya, JKPTJ, this is the local district land administrator. And the last one is the High Court. Okay, so what is the inheritance process? As Jasmine mentioned just now, you need to appoint an administrator. So in this case, I asked my children whether they'll be okay if I am the administrator, because I need to do the running around and I need to go and present the documents and so on. And so they agreed. So from here, okay, again, it's split into 2, meaning what? Either you go to High Court, because if you have assets more than 2 million, or if it's within the range of 600,000 to 2 million. So that's what I did. So I went to the local authority, appointed myself as an administrator, and that's where the challenges start. So the first thing you need to do is do a land or title search, and you have to do it. Again, you know, you can't present the documents. So I went to the local Shah Alam land office, presented, you know, I wanted to see whether, you know, the title that I have of the house is clear and all those things. So you go to Shah Alam, and then if you have, you know, assets other outside Selangor, you have to go and do it in the other states that you have. So after that, after all the documents are in order, that's where you go to the online application, the local, what we call this local land office, and you do all the, it is very tedious actually, because it starts with your name, your IC, your address, and then all the beneficiaries. So, their name, their age, their IC, their address, you have to do all of those things. And then after that, it's divided into two: assets and then, liabilities, hutang. So you have to do it very, very carefully, all right? And took me quite some time to do it, after the 4 times submission online where all the information disappeared. I thought it was a computer glitch. And I discovered that because of the, difference of the Internet Explorer or Chrome. So after I've done that, you actually need to have copies of the documents submitted to the local office. So online is one thing, submitting the documents to the local office is another thing. So went to the office and submitted all the documents. And whenever I submit documents, I will always find out, okay, how long will it take? So this person said at that point of time, 4 months. I said, okay. So they gave me, a stamped letter saying that, okay, documents received. So please don't take their word for if they say it's 4 months and, they're gonna call you and, give you the date. That's not what happened. Exactly 4 months, I called the office and said, look, this is already 4 months. Can I have a date, for the so-called court hearing, whatever. So they finally gave it to me. All right. So this submission was in 2019. I got a date only in 2020, which was last year. So they gave me a date and all of us went there early because they said that, oh, you have to be there by 9. We were actually there by 8:30 like that. So we went there, that means me and my family. Okay. And then we have to bring the original documents, right? And then we sat there. And of course, for our session, it was, para 8, it was asking about this and that. And then the decision was given by the registrar. It's just like a small room. You have a table there. It's like a meeting room. And that's where the discussion came in, right? The discussion did happen. So after the decision is made, you need to get copies of it. So, but before they give you that, you need to make payment. Even though in the official letter they send you, there's no fee, but there is a fee involved, and the fee depends on the assets that you claim, right? And the interesting part here is when when you get to the counter to make payment, it says that, oh yeah, we accept credit card, we accept debit card. So I thought, okay, fine, I'll pay with my credit card because I didn't have that much cash on me. But when I went there, they said, oh, no, we don't accept that. And I looked at the counter, I said, but you mentioned, oh no, that was before. So I was thinking, okay, I don't have enough cash. And then I asked, do you have an ATM around here? Yeah, we have it, it's out there. So went out there, took out the money, paid in cash. So mind you, this payment needs to be paid in cash. They don't accept any other payment. And you need to get multiple copies of the LA. Multiple means, let's say, for example, in my case, my current account or my joint account with my husband was frozen, late husband was frozen. So you need 1 copy for that. And then for the car loan, you need 1 copy for that. For the housing loan, you need 1 copy because every time you go and present, all of this organization will take a copy of it. So don't allow them to give you 1 copy. You need to get multiple copies. That means depending on how many assets that you claim.
Okay. Sorry, Miss.
Yeah.
I think there is not enough time left.
Okay, so no worries. I'm almost finishing. So before I end, what I like to do to share with you, how does the LA looks like. Okay, this is a copy of it that, as you can see, some of the information I've redacted. Okay, so this is the most critical document that you need to have, which is, they call it LA, but everything is in Bahasa. So as you can see, the date given here is 2019. As I mentioned, I submitted in 2019. But the actual date that I have a meeting with them, right? It's actually, if you can see down here, it's 13 February 2020. So it was about 4 months later. And on the front page, as you can see, it mentioned here, all right, there is no fee, 0. Actually, there is, right? And so with that, I end my presentation, and thank you, Cheryl, for the reminder.
Thank you so much, Ms.
Yeah.
Novaizura. That was a very insightful presentation. Thank you very much. Now, with that, we have now come to the Q&A session. And in this session, Ms. Jasmine and Ms. Novaizura will be answering the questions that are posted in the chat box and in Slido. Now, I do see some questions right here in the chat box. I'll do the honors and read out the questions. As for the first question is, if children aged below 18, can I set the will for them?
Okay. I
I'll
think
let Jasmine answer. Yeah.
okay. Yes, you can. You can name your children below 18 years old to be one of your beneficiaries. But in case someone pass away before the children attain the age of 18, they cannot inherit your estate. So the estate will be put under the custody of the trustee. And most of the time, the executor will be the trustee, and the legal guardian can go and apply from the trustee for the children's cost of living and education fees. Okay, so have I answered your question? Yes.
Yeah, all right, thank you. So is it advisable to go to a will writing agency, for example, Rock Wills, instead of a law firm to write my will?
Okay, the difference between going to a law firm and a corporate trustee is this. If a lawyer become your executor, he is doing it in his capacity as an ordinary person. Whereas a corporate trustee is a corporate. So the main difference is ordinary person will pass away one day, but the corporate is a going on concern. So in case, right, anything happen and this individual executor, while he's handling your estate and he also passed away, and then your estate will be halted until his part of the estate is sorted out. So bear in mind, one is with perpetual life, one is without. So with this information, hope you can have a better choice. You can make a decision who you want to appoint to be your executor.
Okay, all right, thank you. Now for the next one is, what happened if the will contested?
Noor, would you like to take this question?
Okay, this is what I understand from the Muslim perspective here. Before I went into the registrar, I actually told my children, okay, this is what I'm going to do with the division of money and so on, because I did not want to do the discussion in front of the registrar. So the minute the registrar sees any disagreement, then it may go to Farah 8, and I did. It's not that I don't want Farah 8, because there are debts that I need to cover. That means I need to still continue paying, like the car and the house. So I did tell the registrar, this assets, please park under me. So in the case of Muslim, if there's disagreement, then it goes to Farah 8. Farah 8 means it follows the Muslim law where, a male gets 1, female get half. In my case, I'm a wife, I only get 1/8. So that is what I understand from the Muslim perspective. I'm not very sure where non-Muslim is concerned. Yeah.
Okay, Miss. Thank you, Miss. As for the next one is, what if the estate money is not enough to settle the liabilities of the person?
Okay, can I answer this? That happens to me. I mean, that happens to me. I discovered that there were more debts, because house you just can't simply settle, it's few 100,000, car as well, right? So I went to the bank and I said, look, I want to continue paying, would you allow it? And it took them quite some time to get back to me. But at the same time, I was still continuing paying it. So it doesn't matter. To me, it doesn't matter, because when I submitted the documentation to the local office, they recognized the fact, okay, there was no issue over it. So it's fine. That's what happened to me. Okay, I'm not very sure whether Jasmine have a different answer. Jasmine?
Oh, okay. Just in case the deceased person does not have any estate which is enough to cover or pay off all the liabilities, then basically the debt will usually die with them, because unless he still has some house where the bank can lend loan, then it will be sold off to cover his liability. Yeah, so whatever debt that cannot be recovered, right? The debt owner will just have to write it off.
Okay. Now, for the next question is, what about fees? Can you do hiba without which overrides faraid?
Noor, can you take this question?
Okay. Hiba is slightly different than I would say wasiat. This is what my understanding, because after the the process that I went through, I was also searching for information online. What's the difference between hiba and wasiat? Hiba is something that you set aside, you want to give prior to writing a will. So in the event of your death, that carries on. Wasiat is your will, which you determine, you say, okay, this goes there and so on. So what you want to do depends on you. My suggestion is, and I discovered this also, when you're still alive, might as well you allocate or give the money, to whoever, or bequeath the money to whoever you want to bequeath it. That is my suggestion, rather than, waiting until you die to do it. Will, fine, you can write it, or you can actually, meet up, like my insurance person actually does as well, simple will writing. But if you have a complicated will, one of the suggestions is to go to a will lawyer. That means those lawyers that are specializing in that. I discovered this again when I was going through the process of finding information. So again, it's up to you whether you want to, do the hibah now, or you want it to do in the event of your death. As I said, my preference, you do it now. I mean, you may want to bequeath whatever assets you have when you're alive. Okay, thank you.
I also see one question here from Mr. Chang Yunfa. Do I and my wife have to write separate will, or we can combine in one will? No, you cannot combine, because you don't know who is going to go first, right? So the will actually is a very personal one. Each and every one have to write our own will.
Okay, thank you, Ms. Jasmine. Now, as for those who are still writing in your questions, we'll give around 5 minutes more because there's a lot of Q&As over here that we're looking into. How about this question? Can the executor claim that he or she is the beneficiary of the remaining cash that was not will be the demissed?
Wow, okay. Can I take this? Okay. What happens is, in the process of doing this as the executor, you can, I would say, keep an expense account. Okay, so for example, toll, petrol, and so on. Because when I was doing this, I realized that it costs a lot of money, the photostating, every time you do a title search, it's 50 ringgit or 80 ringgit, and so on. So you can keep an expense account, and from there you can deduct from the estate. That is the best way to do it. And whatever that's left over, and that's where you divide it. But I did not do that. I did not have an expense account, but I did keep, because I wanted to see how much I spent on it. So it was quite substantial actually. And it was quite interesting when I was doing this process. Somebody sent over WhatsApp this quote. It says that money is not everything, but everything needs money. And it's true, so wherever you go and you're doing all this search and whatnot, it needs money. It's not, to me, it's not that cheap, but it's probably cheaper than going to the court, because you have to appoint a lawyer and so on. And also I have a question here I'd like to answer. According to Muslim, yes, if your house is under, or any assets that are still owed to the bank, you cannot hibah. Yes, I agree. When I'm talking about hibah, I'm talking about money that you want to bequeath, or any assets that's already fully paid, you can bequeath. But if it's still owed to somebody, you can't do that until it's cleared. And that's what I discovered also when I was going through this process.
Okay, thank you. Now, there's another one over here, which is it possible to override faraid via prahiba?
I'm not sure about that overwriting faraid, because hiba, you can do it now. That means you can appoint, there's a person, like an insurance person that does this. You can, say this is what you want to do and so on. And it's already, I think, set aside for that. Whether it can override faraid, I'm not very sure, because
not to worry. Perhaps you can leave your email, and we will come back to you and make sure your doubts are clear after the webinar. Because some question very chunky, you cannot answer on the spot.
No, it's not. It's technical, as in it
Technical
requires legal. Yes, legal
Yeah.
opinion. Because I can only share with you guys, the process I went through. So to say whether HIBA can override, I'm not very sure about that. Yeah.
Okay. Thank you so much. Now for, I think who asked the question from the group chat, I think maybe you can send an email in the group chat so that we can just give you the answers via email. Okay, there's one long question right here. If a will have been registered in Amanah Rakyat, but then the individual writes another will in his own hand with some difference, does that will written by hand have any bearing on the original claim? Is it claim or will? Will, sorry, I think the person.
So, sorry, when you say a will has been registered, meaning you have done a will and the executor is Amanah Raya. Is that your question? And then later you write another will with your own handwriting. Will this will override the previous will that you write with Amanah Raya? Is that your question?
More or less, yes. I'm not. I just want to know if that because let's say there are certain stipulations or further stipulations in the handwritten will, right? For example, let's say the person bequeaths his property to someone, right? And then the person who's writing whose will it is then writes another letter saying that while he or she bequeaths this property to another person, if at all the property is sold, it needs to be divided into 3 parts, let's say going to one person, another person, and 3 different people, let's say. But this is not written, but this stipulation is not there in the original, or rather in the Amanah Raya will.
Okay, remember, letter will override a previous will. So whether the executor is a corporate or an individual, it does not really matter, as long as the letter will is written with a proper and valid format, fulfilling all the requirements for a will to become a valid will. Then the letter will actually override the earlier will.
I see, but if it is not, when you say, so it means it needs to be notarized or something like that, with witness and so on.
Need to be
notarized.
Notarized means someone by law.
Yeah.
No need. You don't have to stamp your will for it to be become valid, but you have to fulfill all the requirements. Meaning you have 2 witnesses signing. The will is signed, and then if people want to contest, of course, you must be able to prove that. At the moment that when you write the letter will, you are of sound of mind. Must fulfill all the requirements for a valid will. Then it's valid.
Interesting. Thanks.
Okay, then we have one very last question right here. If your house is under loan, you cannot do HIBA, right? That one was mentioned.
Answered it already. Yep, correct.
Okay, so I think that was our last question. Now, I think before we end today's webinar, I would like everyone here to turn on your webcam so that we can take a group picture. Please don't be shy, show your faces so that we can get a memorable picture. Okay, thank you very much. I've seen cameras turned on. Okay. Okay, oh, there's a lot of cameras turning on at the same time. Okay, I think what I'm gonna do is I'm going to take screenshot and then I'm gonna swipe to the right so that we can have everybody taken in. Okay, so in the meantime, I think I would like everyone to just stay there for a few seconds because of a delay. So I'm gonna take a picture now. 1, 2, 3. Okay, hold on. Let me switch. Okay, one more. 1, 2, 3. All right. Thank you very much, everyone. I think I've got the picture. Thank you so much for joining us. Thank you. And we have now come to the end of the estate planning webinar. Thank you for devoting some of your time here to attend the webinar. We hope that you have learned something valuable from this webinar. For me, it is definitely important to take actions and to do my estate planning soon. I do not have control when I will breathe my last breath, but estate planning is something within my control to decide who will inherit my possessions and valuables, unless I want my loved ones to go through a long and costly procedure to obtain my assets. Ladies and gentlemen, thank you once again. Have a pleasant day ahead and stay safe, everyone. Thank you for joining us.
Thank you.
Have a nice day, everyone. Thank you.